Good morning and welcome to this session on ethics. For those of you that weren't here at the beginning, my name's Myra Patterson from Monash University. We've got 5 speakers at this session, so I'm going to try and keep my presentation reasonably short. So I'm just going to begin with a short summary of some of the core rules and how the ethics system operates in Australia. And then following on from that, we've got Professor Efrat Levy-Lahad from the Sha'are Zedek Medical Centre and co-chair of the Israel National Bioethics Council. I hope I pronounced those right. Dr. Sharon Bassan, Post-Doctoral Fellow at the Faculty of Law at the University of Haifa. Hello. Dr. Naama Carmi.
Yes.
Hello. And last but not least, Professor Jekyll Michael Barilan. So the ethical rules that guide the work of human research ethics committees in Australia. So I'm going to talk about ethics as it applies to medical research, basically complement our data protection laws. And whereas the law sets a foundation, a firm foundation of core rules, the ethics rules operate in a slightly different sphere. Partly they operate on a voluntary basis, or partially voluntary basis. They've been developed by Universities Australia and our main research funding bodies, and so anyone who conducts research in those contexts has to comply with particular rules of ethics, and basically that requires that when you're doing research you apply to what we call a Human Research Ethics Committee, or HREC. As well as that though, the laws of ethics tie in with our data protection law. And basically how that operates is that where our Privacy Act has data protection principles that require, for example, sensitive information such as medical information to be collected with consent, subject to some exceptions. If you are collecting without consent, then again you can go to an ethics committee, and the ethics committee can give approval for that to take place, and that then depends on the application of a public interest test. So basically the ethics committee has to work out, does the public interest in the research outweigh the potential harm to the privacy of the people whose data is being researched. So that comes with consent, and also the rules regarding use and disclosure. So codes of ethics, certainly in Australia, are based on 4 core ethical principles. The first overarching one is respect for human beings, and that it really ties in with the other ones. Then there's research merit and integrity, justice and beneficence. And each of these principles is relevant in considering big data medical research. So, as I've said, respect for human beings is the core tenet of human research, and it basically recognises the intrinsic value of human beings, and it requires respect for privacy and confidentiality of research participants, and due scope to their capacity to make their own decisions to the extent that they're able to do so. It follows, therefore, that any waiver of the requirement for consent compromises respect for the individual within the research, and that's why then you need to come back to issues such as public interest. The requirement for research merit and integrity gives effect to the principle of respect. So research that lacks merit or lacks integrity in some way is unethical, because it requires participants either to give their time or expose themselves to risks of participation for no good reason. And so one of the jobs of a Human Research Ethics Committee is actually to look to see that there is good research merit. And this is potentially relevant, say, when considering research based on anonymised data. I mean, is it really, is there validity to what is being argued? The principle of justice, in turn, involves a regard for the human sameness that each person shares with every other one. So justice issues arise, for example, where the results of big data analytics have the potential to result in the differential treatment of specific socioeconomic or other groups. And so I think there's been a little bit of mention of that already today, but one of the things that a research ethics committee needs to look at is sort of what might be the consequences of that research. The final principle, beneficence, can be defined as concern for the well-being of others. And in practical terms, that requires that the likely benefit of the research must justify any risks of harm or discomfort by participants. And this creates issues, obviously, in the context of research based on big data, due to the difficulties in predicting accurately at the outset both the potential risks and the likely benefits, because that's one of the characteristics of the big data, that you go in and you find things maybe that you weren't expecting. So how does one weigh up those particular issues? So current codes of ethics share a number of common features with data protection laws, and that's going to be discussed later on in another session, and my colleague Norman will be talking about some of those issues. But firstly, as the Australian ones now operate, they rely very heavily on consent as a basis for permitting collection of identifiable or potentially identifiable information and its use and disclosure. And so basically you go to a human ethics committee and they ask, are you collecting this information with consent? And then if you say yes, then it's sort of, they don't have to do that formal public interest balancing exercise. But of course, that creates issues in the context of big data, because what are you necessarily consenting to? So consent is an issue, I think, that isn't fully thought out in the context yet of the big data analytics and what one does about it, and can one have sort of bulk consent or consent for things that you don't really know. Second, their focus is on the identifiability with an emphasis on individuals. So in other words, will this data identify specific individuals? If so, it raises privacy issues. If not, it's regarded as being okay. And I'll come back to that in a second, but it's not really concerned then with groups, only with individual identifiability. Thirdly, they're based on distinctions between data that's de-identified or anonymous and receives minimal or no protection, and data that's identified or potentially identifiable that receives more protection. So again, when you put in your application, you have to say, is this data going to be pseudonymised? Is it going to be fully anonymised? And the information that's given to participants is based on that. But there's sort of an assumption that, yes, you can tell that there is anonymisation and that's it. And if it's anonymised, no privacy issues and so on. And finally, they distinguish between data that is and is not publicly available. So if you say, I'm just collecting data from the internet or publicly available data, there's still ethics issues that will arise, but there's an assumption, not privacy issues, because it's already out there, it's public, and therefore no privacy involved. And clearly, again, that's problematic. So to summarise what I see as the four issues that we need to think about in terms of our own codes of ethics in Australia that arise from big medical data, there's four. So firstly, the issue of consent that I talked about. The moment we just have the assumption that the research really involves a single study to answer some specific research question or questions, and therefore that it's possible to predict in advance how it may impact on the individual research participants and to provide them with a level of information that's required for informed consent. And one of the things ethics committees do, they look very carefully at the consent form. And when you put in your application, you have to put in the consent form. And the consent form really has to explain to the participants what their risks are, what's going to be done with their data, how it's going to be used, and so forth. This is problematic because, as I've said, one of the uses of big data is to reveal unforeseen connections and patterns. So how does one deal with that issue? And, you know, what possible alternatives are there? Do we need more transparency in terms of possibilities? Do we need broader consent mechanisms? But then obviously they're less protective of the sort of dignity and so forth of the individual. So quite a difficult issue that I don't think we've even started to think about very much yet in Australia. The second issue is the current emphasis on anonymisation as negating the need for consent, which is problematic for reasons that we've already been talking about today. It assumes there's a need for consent only in relation to data that identifies individuals. However, it's possible for organisations to take action or make decisions that impact on individuals whose identity is unknown, in precisely the ways anonymity has long promised to defend them against. So you can still be discriminated against because you are part of a group that has particular characteristics, and yet that's not currently taken into account. So big data has the potential, I think, to result in group-level harms, which then impact on group members as individuals because of their shared characteristics. And I think we've already talked about some of those things. If you're a group that's more likely to suffer from a particular illness or condition or whatever, and I mean, and that's where other laws become relevant, as in, can that data go to insurers? Can it go to employers? Can they discriminate against you, charge you higher premiums, those sorts of things. So that's an important one. A third issue is the ability to aggregate and cross-reference data sets on a large scale to anonymisation may shed light on the identity of individuals whose data has been anonymised. I mean, I think we're seeing, and we've already had the discussion, one of the impacts of big data analytics is that it challenges anonymisation, and we've talked about, we've had an interesting presentation on differential privacy and so forth, but currently is the way our ethics committees work is that, okay, if you don't have any identifying characteristics clearly there, that's anonymised data, that's fine, no issues. And again, that's clearly wrong, but what do we do about that? And it may be that anonymity is okay if you can put other safeguards. I mean, it really depends, can it move beyond those particular researchers and what happens? But at the moment, you put in the consent form and you say this data will be anonymised. And then the data subject thinks, okay, don't have any privacy issues. And clearly that's problematic. And finally, big data analytics challenges the common assumption that publicly available data sets do not raise privacy issues. And there have been a lot of studies where people have used social media and so forth to glean information about people. This is publicly available data, but it has immense privacy implications for those people. So again, that's something that our ethics committees are going to have to grapple with. So, to my mind, those are the four issues for us in Australia. I think codes of ethics do provide a really useful way forward. You know, the law itself tends to be quite blunt, and if you can develop codes of ethics that work well, they can provide that measure of flexibility. But I think for them to do that, we've really got to think about how we deal with these four issues in those codes. Thank you.
Thank you.
Okay, so we now have Professor Ephrat.
As you wish.
First, I'd like to thank you for inviting me. In my normal life, I mostly do medical genetics, and I do research. And the reason I'm saying this is because you know, the research vibe is always positive, right? There's new stuff. We always want to find out new things, and it's exciting and innovative. And when I deal with ethics, I sometimes feel like I'm somehow thought to be sitting on the other side of the fence, trying to stop everything wonderful from happening. So I do want to say that I think I have a view from both sides of this fence, and that's why I first want to make a statement that I think that, you know, big medical data offers us significant opportunities for advancing human health, and I would go so far as to say is that if we have such opportunities, we have a moral duty to use them. So it's not just a question of should we be allowing this, we absolutely should be doing this. I will say it's a little hyped. I want to remind all of us in the room that association is not causation. For those in the physicians or scientists in the room will understand exactly what I mean. 2 years ago, there was a big session in the American Society for Human Genetics meeting. There was a big session on big data. The speakers were the person who runs IBM Watson, I forgot his name, I apologize, the chief engineer of Google, and Muin Khoury, who's head of genetic epidemiology at the CDC. And the Google person showed how they thought they could predict influenza by looking at Google searches. It didn't work that well. But they can't predict your race if they have your blood sample and they look at your polymorphisms. And then Muin Khoury stood up and showed very convincingly that in the United States, margarine consumption is very, very significantly associated with divorce rates. So all of you who want to keep your partners, please do not eat margarine, okay? So obviously this is, I'm giving a facetious example, but it has a purpose. So, you know, that being said, so I think we have to think about, you know, will the benefits be as we hope we are? But at this point, I'm going to assume that they will be. But I still think we have another ethical duty, and that is to think how we can do this ethically. And we've heard a lot of positive things this morning, but I just want to give examples. So Professor Grossman, who is I think he stepped out, he gave this wonderful example of how we might be looking for drugs, better drugs for hypertension, when in fact we should be dealing with compliance. That sounds great. We're now going to look for new methods to improve compliance. Well, you could also say that in Israel, thankfully, all of citizens have medical insurance, but 80% also have supplemental insurance. Now, your insurer could come and say to you, Mr. Cohen, you are not compliant with your hypertension medication. We will not give you supplemental information unless you start complying, or you're going to pay higher premiums. Or things of that nature. So I think we cannot ignore the fact that there are, that there can be negative impacts, and we have to deal with them. The other, I would say, big elephant in the room is the monetary gains. And I think one of the problems is when we're having these ethical discussions, the stakeholders in the room, and there are many stakeholders for big medical data, medical institutions, academic researchers, commercial companies, pharma, and these are all entities that absolutely should be stakeholders. They're looking at the golden pot at the end of the rainbow, and they're saying, how are the rules that you're going to make today going to affect the size and shape and whatever of my pot? And I want to say that, money makes the world go round, and I think it's absolutely clear that none of this is going to happen without commercial incentives, without IP, and that's all okay. The question is, are these things exclusive? Should they be limiting access? Is it ethical to say that because, I can gain IP for medical data that I'm holding as a public trust, because I view medical data as a public trust, and I'll get in a second to why I think that way, does that mean I am the only person who's or I'm the only entity that's going to benefit from the economic rewards? Or should we think about how we share that? So I'm saying that because to say, again, I'm for it, there's going to have to be commercial investment in all of this, but it doesn't mean that we need to shape the ethics around the thought at the end of how the money is going to be shared. If I want to look at an ethical analysis of this issue, I think there's two ways to look at it. One is from the general principles, which I think you so nicely outlined. Gil Siegel will be here this afternoon. He promotes a brand of ethics called Ethics White and Blue. He's saying, how's this night different from all other nights? So how is Israeli bioethics different from other bioethics? And I think where our bioethics are different have to do with the specifics of the Israeli system, that we absolutely have to think about when we're doing this. One is public funding. All of the medical data in this country are 99% funded by our tax money. So it's not, obviously, you know, specific research institutions get private donations, get grants, whatever, but they get these private donations and grants because they have the data for which people give these grants. And all of this data was generated by you, me, everybody else sitting in this room. It was improved by the health systems, it was refined by them, it's made shinier, they go back and forth and look at it, but that's fine. But I would argue that it's all, not argue, I think it's clear that it's all based on public funding. The other thing is that we are a small country. You've heard that each one of us has a unique ID number from birth that follows us everywhere, from our bank account to our army service to everything. This has obvious advantages, but it also leads to significant privacy concerns that maybe are much lesser, let's say in systems like the US, where the health system is much more fragmented. And the other thing, we are a country that has culturally low regard for privacy. So, you know, it's very, each person in this room knows that they want to find out something about somebody. They often have ways to do so. Patients call me all the time and they say, my daughter came to your clinic yesterday. What do you think about, you know, how's her pregnancy going? You know, sorry. So, you know, so I think this is something, people are making faces, but I think, you know, that's the way, I mean, there are advantages to this type of solidarity. So I think we have to take that into account. If I think about the general principles, I think they can practically almost be summarized in one sentence, and it's happened in ethics many times before, and we're really talking about the tension between personal autonomy and personal privacy and solidarity. So the solidarity part of it is that if we all give our medical data, we will all be better for it. We, our children, everybody will get better health. But it doesn't mean we can ignore the autonomy and privacy part. And the question is always going to be, you know, where does that lie? And I want to make another comment about the implication of solidarity. The implication of solidarity is that we are demanding that every person in the country give their data to this wonderful enterprise. And I mean it seriously, that it's a wonderful enterprise. But if we're asking for that, and we're going to waive certain requirements of consent, because we will have to, right? You cannot ask every person in the country to opt in because they're not going to do it, and the data will be worthless if not everybody or practically everybody participates. But if we make that demand of solidarity, we also have to give back in the name of solidarity. So we cannot have the fruits going only to commercial enterprises, only to specific medical institutions. It's got to be shared. And the other implication of solidarity, in my mind, is access. It means that if this is a public enterprise in the sense that we're asking all of our citizens to participate in it, then certainly academic researchers should have fair access to it. Now, fair doesn't mean that it's entirely free. Each person here is going to sit in the room and say, oh, but you know, we spend thousands and thousands of dollars perfecting our data so it can be useful. Fine, you know, decide what's a reasonable amount of money to request for that burnishing of the data. But it has to be real access. I'm going to finish by looking at, you know, what are solutions to this issue of the tension between privacy and autonomy and solidarity. I think there should be a huge emphasis on public education. Right now, this whole system in Israel, in Maccabi, in Clalit, everywhere else, is operating under the advantage of public ignorance. People have no idea that their data is being used in this way. People have no idea that their data has been sold in this way. And everybody's sitting and trying to say, well, let's just keep it quiet, right? And let's keep the wheels rolling. I think this is a big mistake. And the example is what happened in the UK with the care.data program. If people are familiar with that, the idea was that the NHS would pass on all of the people's personal records to a centralized system that would offer commercial access, etc. And the whole thing had to be shelved completely because of privacy and autonomy concerns. So I think we really need to have a system of public education. The other thing we need is ongoing transparency. People should know what's being done with their data. It's not a problem in this day and age. It should be participatory, just like VAR does 4 Ps, participatory. This should also be participatory. There should be a website showing all of the studies that are being that are being, no, I'm just, I'm just suggesting it. And I think, you talked a lot about institutional review boards. I don't know how many people in this room are aware, but Israel has an animal experimentation law, but we don't have a law governing the use of human subjects in research, because that law somehow never gets made. And it's all based on various regulations, and these regulations are partly adequate to deal with big data types of research, but largely they are not, and there's going to be new structures that will need to be put in place, because we need privacy experts and computation experts to look at these types of studies. So we're going to need new structures. But I actually think that the emphasis should be in a completely different place, and that is on enforcement post giving permission to do a study. At least in Israel, what happens is you have to go through incredible hurdles to get your studies approved. I'm speaking from the research side of the fence right now. And then once you've got your approval, maybe somebody's going to come and look at it. Many times not. And I think that really, given the fact that I think what's been clear in the previous session is that there is no such thing as anonymity, and there is no such thing as true privacy, given the will to hack it, okay? Then I think what really needs to be done is to be looking at mechanisms of post-permission enforcement.
Thank you very much. Sharon. Thank you. I'm going to rewind the discussion just a little bit and maybe try to distinguish between research in big data in medical records and health-related research in big data, which is not the same. Because you have been talking about research in big data in the electronic data, medical records, right? But then Professor Grossman mentioned that they're looking at the information whether or not the patient bought the prescription, the medicine or not, right? This is not medical data anymore. This is
medical data.
Is it?
Yeah.
For you, it's medical data?
When the patient comes, I have to know whether he bought it.
And then when
but many times.
And then when Google looks at the web searches of who is looking for symptoms for flu or for influenza or whatever, this is also medical data?
It's medical data, but it's not a personal medical data.
It's not electronic records of the person. Right. Yeah, this is what so I would say that this is health-related big data, but it's not medical data per se that belongs to one person, right? And all the things that we're talking about today are mixing between these two. So in the future, there may be a reason to look at, I don't know, Facebook profiles, and then they're not anonymous and they're not encrypted in any way, and they will be able to connect them to electronic data, to electronic records, medical records that would be highly personalized or highly de-identified and protected. So, and any research in human beings, not only medical research, should have a very delicate equilibrium between the benefits and the harms. And I think that the mixed data set that we're dealing here with is making it very, very difficult. And we know that this data is very valuable. Just last June, they published that 3 health organizations in the United States were hacked, and insurance companies, and each data set was sold in the dark web for between $100,000 and $500,000 for each data set. Yes, and we know even studies show that employers use this data to look at future employees, and to look at employment decisions that they make regarding promotions and stuff, and they rely on the medical data. So on the other we have the large benefits and the great advancement that we heard everybody talking about, but on the other hand, we have not just potential for harms, but just known things that we know now that are already harms. And the thing is that in order to deal with this, we have a lot of rules. So in the beginning of the millennium, we had the genetic revolution. We had great promise in genetic research, and we had a lot of concerns because while medical data was very personal, suddenly genetic data implies things not only on the persons themselves, but also on their family members and their congregation, their community. So there is nothing new under the sun, as was mentioned here, but the scope is very new. And the scope may imply that it would be impossible to prevent privacy violations. So the question is, how do we deal with it? So for example, regarding genetic research, what they did is they changed the default rules and made them stricter. Regarding a lot of the laws, the levels of confidentiality rose and it became stricter. But now today we know that people are hacking. Again, we have there was a study in Harvard of someone who showed how they can use de-identified information, and then they used the chart that shows when people with certain diseases check in certain laboratories to do certain exams, and they could get to the name of the person whose details were de-identified. So the de-identification, I know that it's the magic word around the table, but it's not necessarily a magic word. And this also implies on informed consent. So when I use Facebook, then they say, well, just accept the terms of use, and I accept them automatically, because if I don't use them, if I don't accept them, I cannot check in, right? So I check this box, this little box, and it says, your data may be used for research. That's it. Which may be fine for research in Facebook, but it's not as fine for medical research. Moreover, when I give informed consent for normal treatment, I need to get certain information and to give consent. When I give consent to be a participant in a subject in a clinical trial, I need to get much more information, and my consent should be based on a whole different scope of knowledge, which I don't have. Here, not only I just check this little box that says that it would be used for research, it does not tell me which research. I cannot opt out, and there's a little clause saying that the company may change the terms of use and it does not have to let me know about it. So they may say, hey, we're going to sell your information, but you may never know. And of course, you may never know which research it is used for. And I may be okay with the government or the HMOs using my medical data, but I may not be okay if 23andMe or whatever other commercial or pharmaceutical company would use it to make millions, and if they're using it to make millions, I want some. So, the informed consent is very, very deeply connected with the terms of which data are we using, for what purpose, and which sort of informed consent we have to get. And and today we can see the ways to look at informed consent. We have all the scale. There are people who think that since it's very beneficial for the entire community, then we should assume consent, because it will just benefit future generations and the entire population. We share the knowledge, blah blah. we've talked about it. I don't want to. And on the other hand, we see that we have all the informed consent to use my data when it's public, informed consent to use my medical data, informed consent for medical research, which is completely different. So I think we should just we should pay very close attention to the use and to the sources, and when we're approving this or regulating this.
Thank you.
Thank you.
Okay. Big data presents us with new ethical challenges, but does the fact that we are dealing here with medical big data change the character of the data itself? I think not. So I'll sketch out 3 points regarding the ethical consequences, problems, or concerns. Now, it goes without saying that there are advantages as well, but from the ethical point of view, I'm indeed interested in the concerns. So the first point is, whose information is it? Who actually owns the data from patients' medical records? My answer is unequivocally that the information is of the patients. But many doctors assume that it's theirs, since they made the input. And it's really not a joke. Dr. Eric Topol, who is, among other things, editor-in-chief of Medscape, wrote in a column about paternalism in medicine that his previous column about dealing with the question of, indeed, of ownership of the medical records elicited more than 450 comments, which was a record number, so he says, for all of the posts he had written for Medscape over all the years. In that column, he presented a survey about health-related digital technology, asking both physicians and patients the same questions. When it came to the question of who owns the medical records, 54% of the patients thought they own their medical records, while 39% of the physicians thought they, the physicians, own patients' medical records. 39%. Many comments to that column said the same thing, that the record is theirs, the physicians, since they created it. Indeed, paternalism in medicine. Now, and it's a view, by the way, I heard myself from physicians during the years. Now, this issue relates, of course, not only to the question of big data, but also to questions like, is the patient allowed to see her medical record and the notes the physician made? And I must say it's also very interesting and sometimes appealing to see what your doctor wrote about you in your medical record. And I'm not sure you will want it to be passed to a third party. As a matter of fact, writing irrelevant notes that also cannot, by law, be erased later is ethically forbidden in the first place. Now, the second point is indeed the point of consent. Since the information is mine, as a corollary, I have to give informed consent if researchers want to use it in different ways, including, of course, analyzing and processing it through big data methods. The idea that personal, sensitive medical information about me will be used as data and serve different goals without my knowledge, let alone consent, is disturbing and ethically unacceptable. Even while occasionally surfing in the internet, I get, at least sometimes, or most of the times, informed about the different uses for which the information gathered there is used, including distinctions between uses of identified data and anonymous data. Now, medical information is one of the most sensitive, indeed maybe the most sensitive, of all information that can be gathered about people. So the informed consent should, like always in medical contexts, be very specific and very accurate, including a real possibility not to consent. And also understanding that unlike taking part in traditional medical research, dropping out in the middle might be actually impossible, since the data was already collected and processed. And if we're talking about medical databases that include identified or partly identified or information that could be identified by in different ways, should also be subject to the right to see the data and an opt-out mechanism. The last point is the general point of information in the wrong hands or unethical uses of the information. And this, of course, is a common problem of collecting data. Data can be leaked, it can be hacked, it can be sold, etc. But again, due to the character of the information collected, the problem is acute. The fact that Google, for instance, was given by the UK NHS access to a wide range of healthcare data on 1.6 million patients is very disturbing. It was mentioned here briefly. I want to specify a little bit in order that we'll know what we're talking about here. The information will include information about people who are HIV positive, for instance, as well as details of drug overdoses and abortions. The agreement between the NHS and Google also include access to patients' data from the last 5 years. The data includes logs of day-to-day hospital activity, such as records of the location and the status of patients, as well as who visits them and when. The hospitals will share the results of certain pathology and radiology tests. And to give just 2 more examples, genetic information, not only genetic, but genetic information in the hands of insurance companies can have serious consequences, starting from charging high premiums and ending in refusal to insure patients altogether. And
they're not allowed to use it. No, they're not allowed.
Well, it happens in the USA, so I'm not sure here it won't happen. Many things that are not allowed happens, so we have to watch, to be very vigilant. Employers, it was mentioned as well. A different issue has to do with the amount of information that one can get from cross-checking the medical data with information that patients give about themselves publicly, like in social media, for instance. And it was already mentioned here, the difference between the kind of information that I am giving in Facebook, for instance, is not the same as information that I know that is going to medical research. Again, a thing that already happened. They're not allowed to, but it happened. This can produce, with neither the knowledge nor consent of the patients, very different uses of information and outcomes. And some of them, we must stress this, are unpredictable. So we don't know what we are giving consent to, if we are giving consent. Thank you.
Thank you.
Professor Jekyll Barilan.
Thank you very much. In brief, I'll try to list 3 points that I think challenge our understanding of these issues. The first one has to do with my privilege of being part of research on forensic big data. One of the scholars I work with, she's in the DNA lab of the Israeli police. it's a different world. And what I learned was how little oversight big data in the forensic and homeland security context there is relative to oversight over medical research. And history goes this way. I mean, permission in the Middle Ages to perform autopsies on the dead had been first given in the context of forensic investigation before medical science. And the key answer, explanation for this, I didn't say justification, but psychological explanation is that people, talk about respect for autonomy, people usually care less about objective benefit than about not being suckers. So, so if there is a suspicion of terror, misdemeanor, some abuse, we are much more willing to expose ourselves than, in many ways, I think, much higher chances of getting the medical good of others. And the next point, there's another challenge. In many countries, there is a moratorium on the use of genetic data for insurance plans. This goes against the ethics of insurance because it deprives low-risk people of bargaining for lower premiums. But for many people, and I agree, it's fine, because values like respect for persons and other moral values often, in our society, over trump financial benefits. Well, what about barriers on the use of genetic data for medical research? So you might say, well, we are not talking about financial benefits here, we are talking about medical benefits for others. And here, respect for autonomy is a very problematic value to implement, not to respect. We get into the NIMBY phenomenon. I want the best medical treatment, but not on my big data, but someone else. And one may reconstruct all sorts of situations, Wolfsian-like situation, when we consult the citizens who are healthy about the use of the data, although they are sick. It is similar. However, as Professor Lahad had mentioned and others, when we are talking about medical research and development, somebody is making money out of it. So here again comes this internal conflict. If I use of my data for medical benefit might be fine, but somebody's making money out of it, so it goes against the biblical prohibition not to be a sucker. And we have to see ways of resolving it, ways that are both psychologically valid, but also morally valid. And the third point, if I may mention, we need to use our moral and factual concepts in a thicker way. And one example is the use of the word property, whether medical data is the patient's property or the physician's property. It's not well constructed. Suppose we go with the camp that it's the patient's property, and we can ask, who thinks the patient property? Raise your hand. So we are not students, I'm not doing it. Okay, but fine, you think so. So here comes the patient to the doctor, says, this is my own property. I want you to blot out this diagnosis, put another one. It's my property. I mean, this is my property. I write whatever I want. So it goes against our logic. There are those who think it's doctor's property. Raise your hand, don't need to raise your hand. The doctor says, I write whatever I want. So it doesn't go this way. And property is a cluster concept, we call it in philosophy. And we need to understand the use of cluster concepts and the different uses. Suppose the patient doesn't want to alter the data and say, you are lying. He says, okay, I don't want this Kopat Cholim, this insurance service anymore. Blot my data out. Is it a valid request? And I don't think the law grants the patient any right to delete his own data. You may cease providing information, but what is there is there. You can ask for extra protection, extra protection, not to take it away. And one last example is the whole idea of property in another way. So as this genetic testing, and it's my data, and I want to know it or to publicize it. What does it mean, my genes? It's my mother gene and my sister genes as well. in what sense is it a personal data? So we have the notion of privacy in what, in another context, I call our biographical privacy is what I write, what I tell people, what I write on this page. This is highly, highly, highly protected. But things that are part of me with no relationship to my agency, and particularly when I share them with others, in what way are they mine? And the big risk here that people would wish to expose data. We spoke about protection. So I go to a psychiatrist, I tell him all sorts of things about my father and about the genetic test of my mother, and then I go out with this data because this is mine. And much of medical data is relational. It's on other people. And if we delete all relational aspects for our medical data, it's like deleted medical data whatsoever. I have 10 minutes, right? So that's it.
Thank you.
Thank you very much.
I'd like to chip in.
Sure.
There's something that came up a few times in different talks, and that is property and privacy. And we often, the discussion around this table up until now sort of conflated the two. I think it's a mistake. It's an analytical kind of mistake. Privacy is a fundamental human right. Let's replace privacy and let's talk about free speech. We would talk about our free speech interests not in property terms. There's no reason why we should talk about privacy in property terms. And once we acknowledge that, we can come up with complex situations. My data can be owned by someone else, for example, if I sold it, okay? But nevertheless, I might still have a privacy interest in that data. Now it's difficult, because we don't have the language. We ask, whose data is it? It's my data. So my data sounds like a property kind of discussion, but it's not necessarily my data in the sense that I can sell it or do what property owners can do with their assets.
Sell it as well.
Sorry?
So others cannot sell it as well. It's possible that you can sell it, but someone else can sell your medical data.
Someone can sell my medical data as long as they maintain my privacy interests there. It's sort of
consent to it.
It's conflated. And if I consent to everything is fine. If I consent only, I hand you the information, you can do transactions with it, but under my conditions, it conflates privacy and property interests together, and sometimes it's very difficult to separate them. Analytically we can, in practice it's sometimes more difficult, but it might point to an avenue of solving some of the issues over here and creating new ones, of course.
Michael, can I just make a comment in relation? In Australia, we've got a case that was decided before our privacy laws came in, which said that the medical data belongs to the doctor. However, subsequent to that, we brought in privacy laws that apply in the private sector as well as the public sector, and under those laws, people have rights of privacy in relation to so they're entitled to access, for example, the medical record and see it and get a copy of it. They can also request that it be amended, and then if they can prove that it's incorrect in some way, then it can be amended, or they can put a little statement saying why they disagree with that. So in Australia, the issue of ownership has in a way gone away, because if someone wants to deal with my medical data, then they need consent and so forth. But then I have those rights of access and amendment, which are nothing to do with ownership, but they come from the privacy laws. So that's how we resolve it. Are there any other questions? Yes.
A comment and a question.
Can you please present yourself?
Noam Zohar from Philosophy, Bioethics, Bar-Ilan University. And the comment is that due to the question about divorce and the consumption of margarine, I think it's very understandable that there is a causal relation there. Divorce causes the increase in the use of margarine.
It could be the opposite.
Tongue in cheek, but in terms of
what do they use it for is the
ethical concerns, I think that it has been mentioned by several people in this session and in the previous session by its curiosity. There's a question of the benefit, and you focus on the individual worrying about harm to oneself or the risks, and forgetting that I'm also part of the big society that will gain. But that, in the end, if you push that consistently, you might, I think, end up with the wholly utilitarian conception, because utilitarianism is notoriously indifferent to the question of how the risk benefit gets distributed. If the overall benefit computed over everyone, and that still, you might say, it's still the rational way to go, because if statistically I stand to gain more than I'm losing, then I should opt for that. But even if we don't talk about the common Tversky kind of things that is hinted to, there's still a question of what we try to capture with the notion of rights. That is, there's something which, even if I will lose from it, or if it's not rationally beneficial, I still have certain things which are completely unacceptable to me, or the emotional pain is, or harm or threat is perceived as too great. So, of course, you spoke in a more careful way about balancing. So, balancing can always mean yes, but I do give a certain primacy to rights, even if they're not complete trumps. But I do fear that pointing to the great benefits can move us too much towards obliterating the question of who is gaining and who is losing. And this has to do with the monetary questions, but also with the health benefit questions.
Thank you.
Is the lady over there?
Yeah, sorry.
Hi, Susie Fisher from the Open University. You seem to be assuming that medical information or medical data is mainly physiological. And I just want to remind you that just about a year ago, there's been a new law in Israel that anybody who's seeking psychiatric help has to go to his medical organization and be, identified by your diagnosis, whatever. And here we are in a situation wherein this is a new piece of data. It's not exactly what we have in mind when we think of medical data. Now, even if you take cases where you de-identify things, I think that you could learn a lot from researching this kind of information, how it reflects on communities and society, and not even if it isn't personal, we might find a big congregation of psychiatric say located in a certain community, and it reflects on the community. It's not exactly like racism in ethnic groups, but it's in the family. So also it could be temporary. So what happens if somebody was and then 3, 4, 5 months later, the physician tells him, okay, you're fine, you're great, it was just a temporary nervous breakdown. 5 months and the information is in, it's out, I think it's valid. Especially in regard to the new law here in Israel.
Yeah, certainly in Australia, psychiatric data is regarded as one of the more sensitive categories, and I know psychiatrists have been at the forefront, or were in the early days, in terms of trying to protect privacy.
They're not concerned of big data issues or anything?
Well, I mean, big data is now coming in, so yes, I think that's going to be an issue.
It also has a consequence of justice, because what people are doing is they're going to private psychiatrists in order their information won't be in their medical record of Kufat Cholim. So then the research and the data is only of the poorer people who don't have this possibility. Exactly like people who don't want the mitmache to do the operation are going to their supplementary insurance and are choosing their surgeon. And people who can't do it are actually being, we are doing research on them.
You could say that's an advantage to them because you're going to get your conclusions are actually going to be applicable, especially to them, and they're going to be useless for the people who practice.
Yeah.
No, so I think you have to
Two
realize
sides.
Yeah.
And also, if you don't have it in your file, the family physician won't be able to do good decisions because it's part of the medicine.
But if the family physician is transferring my data, I don't want him to do decisions.
You know, the same.
Okay, guys, thank you so much for this panel.